Gary, can you begin by explaining to me how the FSA regulations have altered the way your company does business?
Fundamentally, they haven't really changed the way we do business. I think what's important to note is that it's more formalised what we do. From day one, we've always been a firm that have done things properly and have been wanting to build a sustainable business. So the FSA's regulations have really brought about a framework in which we can now operate in.
And do you stick totally to the FSA regulations, or do you have your own set of regulations over and above that?
No, we stick with the FSA regulations. Of course, we're authorised by them to provide advice and to arrange sale and rent-back agreements for our clients.
So give me, in a nutshell, what those agreements are and how they affect your company.
We would take an inquiry from a client, and we would talk through a case with a client that's typically under some form of financial distress. Maybe that's mortgage arrears or mounting credit card or unsecured loans. We would complete what is called a confidential client fact find, which is a very detailed document to ascertain their current position. And only once we've got that would we make any suggestions as to how that client might want to resolve their financial situation prior to looking at a sale and rent back agreement. And a sale and rent back agreement should be something as typically as a last resort.
So are there occasions when you say to people, don't take this route?
Absolutely, we do that daily.
Just give me some of the safeguards that are now in the regulations that ensure that people are not being ripped off.
Okay, what's important is that the homeowner come tenant has the minimum guaranteed tenancy of 5 years. And that's a given. So anybody that's entering into a sale and rent back agreement will be provided that from day one as a minimum requirement of us arranging the transaction.
We have case studies in which people have been paid for their homes up to 40% less than the market value. How are we going to ensure that that kind of rip-off doesn't happen?
Yeah, I mean, it's very clear from regulation that an independent valuation has to take place. In fact, certainly with our providers, generally there are two valuations take place, and the average of the two is used to calculate the ultimate purchase price that the client would receive. It's a very open book, so the client's immediately given a copy of that valuation, and the discount is applied to that. Now, in the market that we operate in today, the funders that sit behind us and actually purchase the properties, they will pay typically up to a maximum of around 70% of market value.
So why aren't they getting 100% of the market value?
Well, that simply wouldn't make commercial sense for the funder, the purchaser of the property.
You have to make a profit.
Yeah, I mean, fundamentally, we do generate an income from arranging the transaction, but actually there is a third party involved, which is the purchaser of the property. And it's those guys that lock in the profit, if you'd like to call it, or the equity in the property on completion.
Why do you think it's taken so long for the FSA to latch on to this and to actually do something about it?
It's possibly a resource issue. I really can't answer for the legislator. I'm here to sort of talk about, the pros and cons of sale and rent, but what was going on prior to regulation and post-regulation. So it's a difficult one for me to answer, other than say, obviously, it wasn't under the radar of the FSA. Much like, if you like, unregulated loans that go around even today, with exorbitant interest rates of 2,000% plus.
What sort of terminology do you use when you're entering into a sell and rent back scheme? Because again, the FSA are very clear that you cannot use emotive or, if you like, bully boy language.
Absolutely, yeah. It's very important that we basically use the phrase that the FSA put to us, which is treating customers fairly. That basically ensures that we are very open with our clients. We don't use any bully boy tactics at all. We turn clients away every day. In fact, we turn more away than we ever work with.
And what happens if a company goes out of business? Again, we have case studies where companies have gone out of business, and those people that have entered into these agreements have no way of getting very huge sums of money back.
I think, again, prior to regulation, if there are clients out there that have suffered from sale and rent back agreements that have gone wrong in the past and lost out, unfortunately there is no protection afforded by the FSA.
Mr. Slater, yours is a company that clearly works very stringently within the FSA rules. How do you feel then, knowing that there are companies out there that are, if you like, operating illegally, who clearly must be giving your industry a bad name? What can be done either by those of you who comply or by the FSA itself to ensure that members of the public know who they can trust and where they should go?
The first check a client should make is that the firm is regulated by the FSA. So that's number one. In terms of what do we think about those companies that are operating non-compliantly, it's very frustrating. Of course it is. It's giving us a bad press. And the very reason we wanted to participate in the programme was because we want to get the message clear that actually sale and rent back today is a credible solution for some people.
What advice would you give to our viewers to ensure that they're not ripped off and that they go to a reputable company?
Yeah. First and foremost, check that they're regulated by the FSA. Take the number down, check the address, check previous clients, talk with the FSA. Make sure that they are a firm that still hold their authorisation. They may have had an FSA number previously, they may have been authorised previously, they may not be any longer. So it could change almost on a daily basis. One firm today being authorised doesn't mean they are tomorrow. But above that, there isn't a great deal more we can do in the market other than to just make those fundamental checks.
But in the meantime, if anyone is thinking of selling and then renting back, and they are not going to deal with an FSA-regulated company, your advice would be avoid them like the plague.
Absolutely, yeah. I think that most of our competitors that were around previously that are no longer regulated, they'll be trying to push people down the road of selling with vacant possession, so to sell and move out. And are probably selling against us in that respect. But yeah, if they're not regulated, I'd just say stay well clear.
Mr. Slater, thank you very much indeed.
Thank you very much.